Thank you very much, Madam Deputy Speaker. With your permission, I will make a statement on a fairer pathway to settlement for migrants. The story of migration in this country is woven through my own. My father came here in the early 70s, my mother a little less than a decade later. Both came to seek a better life, and they found one here. In time, while always proud Kashmiris, they became British citizens themselves, Brummies too, and they brought up 4 children just as proud to be a part of this country and that great city as them.
Right. Picture this. You tweet something perfectly legal, perhaps a bit cheeky, maybe celebrating the fact that someone who has been harassing you for years finally got sacked from their job. Nothing criminal, nothing threatening, just your opinion expressed on social media, as millions of people do every single day. And then, nearly a year later, you discover that you have been recorded by the police as having committed a hate crime. Not investigated, not charged, not even bloody told about it. Just quietly added to police databases with little prejudice markers flagging you as a hateful criminal, all because someone claimed their feelings were hurt. Welcome to modern Britain, where the Home Office has created a system so Kafkaesque, so utterly bonkers, that you can be branded a criminal based purely on someone else's perception of offense, without any investigation, without any evidence, and without even being informed it has happened. And now, finally, someone is taking the government to court over this absolute madness. Buckle up, because this case could blow the entire hate crime recording system wide open. Quick favor. If you are already sensing this is going to be absolutely mental and want to stay updated on every twist in this legal battle, hit that subscribe button and smash the bell icon. Over 94% of you legends have not subscribed yet. It is completely free, takes 2 seconds, and honestly keeps us going here at British Mirror. Cheers if you did. Right, let us dive into this extraordinary High Court challenge. So here's the situation. Harry Miller, a former police officer and co-founder of the campaign group Fair Cop, is launching a legal challenge against the Home Secretary over crime recording rules that allow hate crimes to be logged based purely on someone's perception before any investigation takes place, and without the accused person even being told. Now, if that sounds absolutely mental to you, congratulations, you still have your sanity intact. Because what we are talking about here is a system where you can be recorded as guilty of a hate crime, have that crime go on your permanent record, become part of national crime statistics, and potentially damage your reputation and future job prospects, all without ever being investigated, charged, or even informed that it has happened. It is like being convicted in absentia, except you never had a trial, you never had charges brought, and you never even knew you were accused of anything. At the center of Miller's challenge is his claim that Lincolnshire police recorded a hate crime against him without his knowledge, leaving him branded with a criminal record that could cause serious reputational damage. The underlying dispute involves Lindsay Watson, a trans activist and former Leicestershire police constable who, according to Miller's legal team, stalked and harassed Miller for many years before being dismissed for gross misconduct in 2023. And when I say harassed, I am not talking about a few mean tweets. We are talking about posting more than 1,200 messages on social media over an 18-month period calling Miller a Nazi, a bigot, a wife beater, and a wingnut. 1,200 messages. That is not criticism. That is obsession. That is a sustained campaign of abuse that would drive most people absolutely spare. Now, here's where it gets interesting. Miller says he tweeted 4 times during 2023 and 2024 about Watson's behavior towards him and his family, and celebrating the fact that Watson had been sacked from the police. Just 4 tweets. Not a campaign of harassment. Not thousands of messages. 4 tweets about someone who had been harassing him and had been dismissed for misconduct. Watson complained that those tweets were malicious. Miller was invited to a police interview, explained his position, and then heard nothing further. Job done. Case closed, or so you would think. Except it was not closed at all. Nearly a year later, Miller discovered that a hate crime had been recorded against him, complete with prejudice markers flagging him as someone who had committed a hate-related offense. He was not told. He was not informed. He just stumbled across it almost by accident. Imagine discovering you have been branded a criminal and nobody bothered to mention it to you. This is not some bureaucratic mistake or administrative oversight. This is how the system is designed to work. Under the current Home Office crime recording rules, police can log a hate crime based purely on someone's perception of being offended, even when the facts are disputed, even when there is no evidence of criminal activity, and even when the accused person has not been given any opportunity to respond. Think about that for a second. Your life, your reputation, your future employment prospect can all be damaged because someone, somewhere, decided they were offended by something you said, and the police are required to record it as a crime without doing any actual investigation to determine whether a crime was even committed. The rules literally mandate that police officers dismiss objective evidence in favor of the perception of hurt feelings. That is not justice. That is not policing. That is ideological enforcement dressed up as crime prevention. It is the kind of thing you would expect in an authoritarian state, not a liberal democracy with centuries of common law tradition emphasizing presumption of innocence and the burden of proof. But here we are, in 2025, with a system that allows anyone to effectively weaponize the police against people they disagree with by simply claiming they feel offended. Miller's statement about this case is absolutely bang on. He said the Home Office crime recording rules, as they currently stand, mandate police officers to dismiss objective evidence in favor of a perception of hurt feelings. Everyone is therefore at risk of being criminalized by both the local police force and the state. This is an assault on common sense and on the established rules of evidence. It gives the police a government license to bypass even the most elementary burden of proof and to criminally pursue and record entirely innocent individuals. He is absolutely right. This is not about protecting vulnerable people. This is about creating a system where hurt feelings trump facts, where perception trumps evidence, and where anyone can be branded a criminal without any due process whatsoever. His solicitor, James Gardner, says the heart of this case is free speech, and that the rules are skewed in favor of victims when the allegation is about words, opinions, or online disputes. He said these crime recording rules have a chilling effect on free speech, and that this travesty is a vivid illustration of what happens to innocent people when the police record a hate crime without giving the accused a chance to respond. The Home Office rules are clearly skewed in favor of victims and need to be withdrawn and rewritten because, as they currently stand, they are unlawful. And you know what? He has got a point. If you can be recorded as a criminal for expressing an opinion, even if that opinion is not threatening, not harassing, and not illegal, then we have abandoned any pretense of living in a free society. The legal argument Miller is making attacks the crime recording rules on two fronts: basic fairness and freedom of expression rights. The pre-action judicial review letter alleges the rules direct police to record a crime before any investigation and to record a hate crime based solely on perception of the victim or person reporting it, without informing the accused or giving them a chance to respond. That is a violation of natural justice so fundamental that it is shocking this system has been allowed to continue for as long as it has. In any sane legal system, you cannot brand someone a criminal without giving them a chance to defend themselves. That is Law 101. That is the kind of thing we teach children about fairness. And yet here we are, with a system that does exactly that. Supporters of the current framework will argue that consistent recording is necessary so victims are taken seriously and patterns are identified. And look, I get it. We want to make sure that genuine victims of hate crimes are believed and supported. We want to make sure that patterns of behavior are identified and dealt with. But you do not achieve that by abandoning basic principles of justice. You do not achieve that by creating a system where anyone can weaponize the police against people they dislike. You do not achieve that by recording crimes that have not been investigated and may not even be crimes at all. That is not protecting victims. That is creating a system ripe for abuse. And let us talk about the potential for abuse here, because it is absolutely massive. Under this system, if you have a disagreement with someone online, if you criticize someone's behavior, if you celebrate when someone who has been harassing you gets sacked, they can report you to the police, claim they are offended, and boom, you have a hate crime recorded against you. You do not get told. You do not get investigated. You just get branded a criminal. And that record sits there in police databases, potentially affecting background checks, employment applications, and your reputation. It is a system that actively encourages malicious complaints because there is no downside for the person making the complaint, and potentially massive consequences for the person being accused. Watson's history here is also quite telling. According to the information available, Watson has been involved in reporting multiple individuals to police over social media posts and alleged hate incidents, including Father Ted writer and comedian Graham Linehan. with reports believed to have led to Linehan's arrest at Heathrow Airport. So we have someone with a documented history of making complaints to police about people they disagree with, who was themselves dismissed from the police for gross misconduct after posting over 1,200 harassing messages about Miller, now successfully getting Miller recorded as a hate criminal for 4 tweets celebrating the fact that she got sacked. The irony is so thick you could cut it with a knife. Miller is seeking several things from the court: a declaration that the rules are unlawful where they fail to protect free expression, an order quashing the recorded hate crime against him, an order requiring the entry to be excised from all local, regional, and national crime statistics, and damages, all of which seem perfectly reasonable given what has happened to him. If the court agrees with him, it could blow the entire hate crime recording system wide open and force a complete overhaul of how these complaints are handled. The Home Office's response has been predictably bureaucratic. A spokesperson said they have been clear that they need consistent, common-sense approach that protects the fundamental right to free speech, and that a review is currently underway into public order and hate crime laws. They do not wish to preempt the final findings of the review, which they have asked to be completed at pace. Translation: we know this is a problem. We are looking at it. Please do not sue us before we figure out what to do about it. But here is the thing. This review should not be necessary. Any government with a shred of common sense would have looked at these rules years ago and said, hang on, this is completely bonkers. We cannot have a system where people get recorded as criminals without any investigation or notification. But instead, it has taken a legal challenge to force the issue.